Hello students, very good morning to all of you. Myself, Parth Sejpal, working as CEO SSIP SRIC at Soras University, and I am also a registered Indian patent agent. Today we are going to see the basics of intellectual property rights. In the last 2 days, you have seen the what is entrepreneurship and how you can move further and preparation of business model canvas. So today we are going to see how you can move forward with the your product for the intellectual property registration, that is in India. So first of all, what is the meaning of intellectual property? Firstly, we need to see what is the property. Anything that has some value, like currency, gold, car, land, house, everything that comes under the property, right? And intellectual property means that is a type intangible property, a idea or the innovation or expression, that is called intangible property. So a tangible property can be measured, touched, and have physical form, like currency, gold, house, etc. Whereas intangible property means which cannot be measured. We are not able to measure the exact value or the exact value of that invention or exact value of that property, and it cannot be touched and it doesn't have any physical form, like creation of human mind, ideas, right? So these are intangible properties. So there is one method or there is one process where you can register your innovation, where you can register your idea and you can get uh, rights on it. That is called intellectual property rights. Now we will see different types of intellectual properties. First of all, we need to know what is the invention and what is innovation. These both words we have already heard, right, in past, invention and innovation. So what is the difference between innovation and invention? Innovation means that is some addition or the subtraction of some features from the already existing product or the process, whereas invention means it is something new. It was not in the market and someone came up with the something new product or something new process, that is called invention. For example, invention of telephone, invention of bulb, invention of internet, invention of cryptography, right? So these are called inventions. Whereas innovation, we can say that from telephone to smartphone, a mobile phone, touchpad phone, right? These all are called innovation. Means additions or subtractions of some features, right? Now also we need to know what is the difference between invention and discovery. These two both also we have always heard. So what is the difference between discovery and invention? Yes, discovery means that was already existing in the nature and someone just found out. That is called discovery. For example, discovery of oxygen gas, discovery of carbon dioxide, discovery of America. So it was already existing. Someone just found out. Whereas invention means something new, prepared, something new made from the existing materials, right? So that is the difference between invention, discovery, and innovation. So everything that is innovation or invention can be considered as an intellectual property, and it can be registered in these different forms like patent, trademark, copyright, industrial design, integrated circuit design, geographical indication, and trade secret. Also, currently in 2017, government came up with the plant variety breeds policy, right, where you can register the breed of the plant. A new genetic plant can also be registered under this plant variety policy. So we can say that these are the different types of IP available in our country. Everything that I am going to say today is based on the Indian IP laws, the different acts of India. So everything is limited to our country, India only. So how it works? So these all words once you would have heard. So that copyright means it means the expression of ideas. Then patent is It contains some idea that is having some innovation or some invention in it that can be patented. Then idea that shows some quality or that shows some identity of the uh, company that can be registered under trademark. Then idea that shows some appearance, that is just the overall look of the product, then it can be registered under design. An idea that is kept confidential, no one is disclosing it or it is not said anywhere, that are called trade secrets, right? So these are the how different types of IP uh, evolutions is done. So intellectual property rights, it means generating ideas and we need to own them, means we can register it on our name and we can sell it or we can license it or we can rent it. Basically intellectual property owing means having a intellectual property, we can compare it directly to having a physical property. Like you bought a house, whenever you are getting a grant of patent, it means you just consider it as you bought a house. Now you can use it for your own, or you can sell it out, or you can rent it, you can give it for few days use. Like same way for the intellectual property, also we can do the same way. Like you can sell it out your patent, you can license it, you can uh, rent it out, like. So that we'll see further also, but just to have a basic idea that how what actually the IP is. So IP rights are territorial in nature, as I said that all the IPs are limited to our country India only, up to the territory of India. It usually gives the creator. Creator means the person who has registered it or the person who has made it, right? And exclusive rights. Why it is called exclusive? Because the right is given only to the creator, right? No one else can use it without his permission. Same way as our house, we only the owner can use the house, others are not able to use the house without the permission of owner, right? So it is called a exclusive rights over the use of his creation for a certain period of time. So different IPs have different time validity. That property is owned by that owner for a specific period of time, right? And different IPs different time limit. So first of all, what is trademark? So it protects the brand name and the logos used on the goods and services, right? uh, it distinguishes the product from other identical or similar products, right? A trademark can be a symbol, name, figure, letter, words, right? Anything that shows some brand value, that has some. By seeing the name or by seeing the logo, you would be able to identify that product, or you would be able to identify that identity. So they can register it as a trademark. For example, here we can see these all are the logos of different brands. You cannot use this logo for your own, right? It has some brand value, it shows their brand value and it reflects by their in terms of their logo, right? So they have registered this logo as well as name for the trademark. The validity of trademark is 10 years after registration, and every 10 years you can renew it, right? So it can be a lifetime, but every 10 years you need to pay the renewal fee. By seeing this logo, you can identify that it is. Here I am showing you. I think my pointer will be visible. Here, by seeing this logo, you will be able to identify that is a Windows logo. This is a Shell logo. This is Puma logo, right? So just without the name also, you will be able to identify that identity. So this is Apple logo, right? So this is the trademark. Now the second thing is copyright. Copyright is a legal right granted to the creator for the artistic work. It means artistic work means it can be any form of computer software, of art, or a poetry, or a literature, or notes, book, everything that you created by your own, and you express it in terms of a literature, or it can be a film, short film, music, song. Everything comes under the copyright, right? You can register it as a copyright, and you can get the right on it. So copyright can be a book, it can be a music, it can be a music note. Even if you have created some cartoon creation or cartoon uh, type of structure, it can be also registered as a copyright. Means sketch or a drawing, right? That can be considered under copyright. So and validity of copyright is the longest uh, in terms of validity. It is the having the validity of 60 years plus author life. It means if you are the author or if you are the owner of that copyright, until you pass away, till then, and after that 60 years to your uh, years, it means in total your life plus 60 years give ownership to the your belongings, right? So that is the one of the longest IP uh, validity, right? Then comes industrial design. And industrial design is consists of the three dimensional. It means just the look. Here you can see that the a shoe is there. So shoe is always in the market, but exact appearance, exact look of this shoe, no one can copy it, right? For the shoes you can see that Puma shoes is having different look than Adidas and Reebok, right? So every branded company have their own specific design or specific look of that product. Even the sole, the print of the sole is registered, so no one can copy the sole, or no one can copy the design of that sole. So each and every company would have their own registered design for their product. The cycle, you can see cycle in the market is already always available, but the specific design, the specific look. So anything when you come up with a new look or new image, external appearance, basically external appearance, whatever you come up with, that can be registered as industrial design. But here there is no any technique involved. You can see for the cycle, even though there will be some technique in it, but that is not registered. Here we are only registering the external appearance. For example, I say that Apple iPhone, right? Apple iPhone have registered their external appearance with a front screen having one round button. So that is just the external appearance being registered under industrial design. So no one can copy that type of look. Even if Samsung wants to produce that type of look, they would not be able to use the single round button at the bottom of the front screen, right? So that is the importance of the industrial design. So it basically it registers only the appearance and nothing else, but that appearance also makes some brand value, right? Here are the few examples. The car, you can see that external appearance of a car, like a Tata Nano, same type of car look, no one can manufacture. Even the different cars that are available in the market, you can see that all the brands and all the companies are having different look. They cannot copy each other's look, right? As I said, iPhone, the goggles, even the look or even the design of that goggles also, branded companies are always registering. So you need to register your look or the appearance if it is unique and if it is distinguished, right? Then integrated circuit design. Those who are from electronics or EC, they would be knowing that they are preparing their topography or the layout of their circuits. So these circuits also can be registered as a IC design, right? So no one can copy the same circuit or same topography of that circuit. Then geographical indications, these words we have always heard these names, but we are not aware that what actually it represents, right? So geographical indication is the used on the products that are from specific geographical origin. Yes, I missed that. Validity of industrial design. So validity of industrial design is 10 years plus 5 years, so maximum up to 15 years for the industrial design. So once you register, you will get the validity of 10 years, and after that you can again renew maximum up to 5 years. So maximum it can go up to 15 years, right? Yes, geographical indication, it means the product or the origin, the name has some geographical name or the origin place of that product, like Assam tea, Gir Kesar, Patan Patola, Jamnagar Bandhani, right? Bengal Rasgulla. These all have some name of the place added with their product name. So this shows the quality. It shows the originality of that product. No one person in Gujarat can produce Assam tea in Gujarat and sell it in the name of Assam tea. No. Even Gir Kesar also we cannot show it in the Rajkot and we can sell it in Rajkot as a Gir Kesar. Only the people of Gir or that specific region, they can manufacture this type of product, means they can grow this type of product, and only they are eligible to sell it in the name of Gir Kesar, right? If someone here in Rajkot is growing kesar, and if he is selling in the name of Gir Kesar, he will be sued, right? And that is limited to specific number of peoples, and it is the only IP which is given to a association, right? Not a single people, means not a single person. So all the persons residing in Gir area, their association can get this IP, and anyone of that person can sell the Kesar in the name of Gir Kesar. It means on a type of association. Association can be of 50 members, 100 members, 500 members, right? So those who are associated can get this right. Patan Patola, same way. The people residing in Patan and who are manufacturer of this type of patola, they can only sell the patola in the name of Patan Patola, right? No one in India, no one in Rajkot can manufacture the patola and say this is Patan Patola, right? So this is the importance of GI. It is also valid up to 20 years. So once you are getting some GI tag, then you can use that specific name up to 20 years. I can also give you an example that for Rajkot, we are having the speciality in Penda, right? Many are saying that Rajkot Penda is a type, something variety that we can share to others, that whenever some people come to Rajkot, they can take this penda. So it is famous. So, but it is not registered as a GI. But if the association of our Rajkot people go and apply for it, they would be getting this GI tag as a Rajkot penda. And after that only, no person from Jamnagar or Junagadh can sell the penda in the name of Rajkot penda. Yes, if the person is reseller at that place, then he can sell it in the name of Rajkot Penda, right? But the manufacturer need to be from Rajkot itself only. Like we are getting here also in Rajkot, Porbandarni Khajli. So that is manufactured there only, and it is branded in the name of Porbandar only, and they are the main seller. Here, the person who is selling is the reseller. He is not making it here in Rajkot only and selling. Right? He is also buying it from Porbandar. Right? So yes, then trade secret. Trade secret means the confidential business information, right? So if any owner or if any inventor does not want to share this secret, is he is not interested to share to anyone, because all the other IPs has some validity. After that, it will come in the public. Means after that, anyone is able to use that invention freely. No need to get uh, permission of that owner, right? So that becomes the public property after a limited period of time for different IPs, right? So patent becomes public after 20 years. Trademark becomes, no, trademarks does not become public. If the owner doesn't pay the renewal fee, then it will become public. Otherwise, it will be continued as many as times as he wants. Then copyright will become public after 60 years of the death of the author, right? So every creation will become a public. But if the owner doesn't want to make it public, he keep it as a trade secret, right? so he doesn't share it anywhere. And trade secrets are sometimes it does not meet the patentability criteria, right? It can be or it cannot be. That doesn't that will be seeing in future further slides. So sometimes it would be fulfilling the patentability criteria, but he doesn't want to share, so it will not be shared. The best example of trade secret is Coca-Cola, right? There are many local and national drinks, cold drinks are coming, but no one is able to make the exact taste of Coca-Cola, right? So they've kept it as a trade secret. No one other is able to get that formulation, that how it is prepared. Then Google algorithm. We all are using Google every day, right? Every now and then we are using Google, but how it works, what is the algorithm inside it, that is nowhere said, right? You also know that the result that is shown in Google is most preferable result by us, rather than getting the result on Bing or Yahoo or any other search engine, right? Microsoft search engine, right? So in Google only you are getting the most preferred result that you are looking for, and that's why only it is used maximum by all the users, right? So the algorithm that is used behind it is not shared by the Google, so they have kept it as a secret. No one else is able to uh, prepare the same type of search engine as Google. Then recipe of KFC, right? The same type of chicken we are not able to get at any other place. Same way, this type of trade secret can be at our local markets also, right? We know that there are many places like Gugrawala, right? So specific Gugrawala is having some specific taste. No one else is able to make that type of same taste, even though they are selling the Gugra only, right? So these all are trade secrets. It doesn't need to be registered anywhere, but it is the property, intellectual property of the creator, and they keep it as a secret. So here we will see example of one product. So I am saying that I have prepared this product. So this is my product. So how many different IPs, how many different intellectual properties do I can registered on this product? Can anyone list out that what are the different IPs we can get it on this product? Yes, we can. We move further that we can get almost all the IPs except integrated circuit and geographical indication, right? So a single product can have multi IPs within itself, right? So basically you need to remember all the seven different IPs. What were the seven different IPs? Patent, trademark, copyright, design, IC circuit design, geographical indication, and trade secret. So from that 7 IP here we can apply five different IPs. How we are saying here, right? So novel and inventive. Here we can claim that the crease that is happening at the front of this shoe is novel and it is something new, right? So it can be one type of intellectual property. Then brand name. They have created some brand and they have prepared some logo. So that can be also registered. Then confidential info means they have prepared some solution which binds the upper part and the sole of the shoes, and it is lifelong, or it can be retained a very long period of time. That is something confidential. They are not sharing that what they have prepared and what they have used, but yes, that is something new technique, so they are keeping it a secret. Then external appearance, right? The front look, bottom look, everything, a design pattern, everything that is a external appearance. Then package information or the leaflet. Whenever you are buying any branded product, whenever you are going with some good type quality product, you will be getting one manual with it. You will be getting one box having instructions, right? So this can be registered as a copyright. So all these IPs can be covered for the single product. Now we can see that novel and inventive step, it can be registered as a patent. Then brand name can be registered as a trademark. Then confidential info can be, it can be a trade secret. And external appearance, yes, industrial design. And package insert can be registered as a copyright, right? So here we see that all the different IPs are covered in the single product. So now focus on your product or your invention. What are the different IPs that you can take? What are the different intellectual properties that you can register for your own product, and you can proceed for it. Now we will see in depth for the patent. So before that, importance, what, why it is important, taking the intellectual property, because it secures the rights of invention, right? You are getting the monopoly, no one else will be able to produce the same thing, right? So no one can copy it. So it secures the right, even the final year thesis or the project proposal, everything you can copyright and no one else can copy it, right? So these things you need to keep in mind. Then you can increase the revenue through licensing. As I said that the IP can be licensed. If you are the manufacturer of these shoes, you can give the license to use the same logo, you can give the license to manufacture the same design shoes, right? So by that also you can get a revenue. So it increases the revenue through licensing. Then it can be used as a USP, right? Because it gives the monopoly, no one else will be having the same type of feature in their product, and you will be having the USP for their product. For example, I say that we all would have used the Nokia mobile phones, right? Previously we all were using Nokia phones. So they had patented the round pin charging point. So that round pin, you would be able to keep the phone in any direction, anyway, and it would be charging, right? So they have patented it, so no other phones, Samsung or Sony Ericsson, would not be able to prepare the same type of socket for the charging. So that was their USP. We all remember that Nokia pin charger, right? So that was the best pin. Once you insert it, you can rotate the phone or you can keep the phone in any direction and it gets charged, right? So that is called USP, and you can get the advantage. Yes, if you have the question yet, the same charger socket are used by Samsung and Sony, but they are sharing it. Means one is the owner and another is getting the license from it, and they both are using it, right? So that way also you can get the revenue. Then you can add huge brand value attached to the IP, right? In both the manufacturing and technology sector, right? It is obvious that whenever you see some brand, whenever you see some logo, like by seeing the logo of Honda, you prefer that it is a brand of Honda, and you can go for it rather than any other brand. So anywhere, whenever you are having some good market, your logo and your IP adds the brand value, right? Then boost their revenues through licensing, same as second point. Then encourages the R&D and ensure continuous innovation, right? So more and more company will try to have more and more IP. So adding the intellectual property in their portfolio will increase the R&D in their organization, right? Then important asset having higher value than the physical asset. So now it is clear that the being having an IP is more valuable than having some physical asset, right? As we I just give you one example. Have more ice cream, yeah, right? Have more ice cream was bought by some foreign companies for a very huge amount, right? So it was not buying that the machineries, right? Because getting the machineries from the market is so simple, anyone can buy the machinery for making of ice cream, but buying the brand name, that is more important, right? Because Havemore has brand value. So that was the money that was paid was for the brand value of Havemore and not for the machineries, that we can all understand, right? So it is having a higher value than the physical assets. So this is the importance of IPM. So now, till now, everything clear about all the different types of IP, all the seven types of IP, that is patent, trademark. No, patent will be covered now. So all the other six types of IP, that is trademark, copyright, design, IC design, GI, trade secret, all is clear, right? So if you have any questions, then you can write it in the chat box, and I will be answering you after the completion of this presentation, right? So now we'll be focusing on the patent only. So this is the definition of patent as per the IP law, that is Patent Act 1970 as per India, right? So what is patent? Patent is a territorial right. As I said, that it is limited to only the territory of our country, and it is a exclusive or negative right, right? Because why it is called exclusive? As I said, it is given only to the owner or only to the creator, right? And right granted by government. The right is granted by the government itself. No one else can grant it, right? For an invention. So for an invention, to its creator for a limited period of time. So for the patent, limited period of time is 20 years, right? Also below I have given the what can be considered in invention. Invention can be a product or a process, right? An invention can be a product or a process in new way of doing something new, right? It offers some new technical solution to the existing product problem. So even if you are coming up with a new process or you are coming up with a new product, then it can be registered as a patent. So now we'll see the after this we'll be seeing the eligibility criteria for patent. And why it is called negative rights? Because it permits its owner to exclude others from making, using, selling, right, importing anything. They are not able to sell it or make it or use it or import it from foreign countries, right? So it gives the owner a monopoly, right? It The owner can stop others from making and using, selling, offering for sale without the permission of owner, right? We need to take the permission of owner if we want to sell it or use it or manufacture it, right? So what are the requirements of patentability? So here are the three eligibility criteria for patentability, that is novelty, non-obviousness, and industrial application. We can call it as a 3I. Uh, Novelty means innovation or nowhere in the world. Here focus that novelty means nowhere in the world. The invention that you are claiming, the innovation that you are claiming should be nowhere in the world, right? But the grant is given only to our country. The grant is given only to the territory of our nation, but we need to check that it is the novel. It is nowhere in the world. આખા વર્લ્ડમાં ક્યાંય ન હોવું જોઈએ, right? That is called novelty or innovation. Then non obviousness. Non obviousness means inventive step. It means it should not be the arrangement or rearrangement of the known products, right? Or just adding two three inventions together and we are coming up with a new invention, that is obvious, right? So it should not be obvious, it should be non-obvious. Means we are not adding two three inventions together and coming up with a new invention, right? So this is the second criteria to be fulfilled. And third criteria is usefulness or industrial application. It means it should be useful to the public. It should be manufacturable, not just a hypothetical idea, right? You should be able to manufacture it, or you should be able to make the product in physical form, right? So these are the three criteria of patentability. Yes, whenever you are going to file for a patent, there is no need of any hard product, there is no need of any prototype to be there, but you should be having a theoretical proof with you that this is the method how it can be prepared, this is the way it will be functioning, this is the way it will be working, right? So whenever you are filing for the patent, there is no any requirement, or there is no any model requirement, or there is no any prototype requirement. You can file your patent just on based on your ideas, with a valid proof, with a valid theoretical support, right? Novelty, non-obviousness, and industrial application. It means novelty means, as I said, that it must be new, it must be different from what has come before, and invention should be not publicly known anywhere in the world, right? No, it should be nowhere in the world. Then non-obviousness, it means a feature of an invention that involves technical advancement. It should have some advancement over the existing knowledge, or have some economic significance. Economic significance, it means that it should be cost effective from the existing technology. જે ટેકનોલોજી અવેલેબલ છે એના કરતાં સસ્તી પડતી હોવી જોઈએ. Or it can be both, right? Either technical advancement, either economical significant, or it can be both, right? And it should not be, invention should not be obvious to a person skilled in art. For example, if I say that, if you are claiming that, if for the mechanical students, it would be easy to understand that in an engine, IC engine, if you are keeping the spark plug at a specific angle, you would be able to get more efficiency, right? You are claiming that by keeping the spark plug at 73 degree, you are getting the maximum efficiency. So that is your invention, or that is your innovation, right? Then when you are claiming, but that same thing, the mechanic, or the person who is having experience for the engine, IC engine, you would be easily able to say that yes, by keeping that, it is very obvious that for that angle only you will be getting a maximum efficiency. So that will be against the obviousness, right? So it would, so you would not be able to claim the non-obviousness, because the person who is having the skill is already knowing the thing, right? So you would not be able to get this patent. But you can, as the patent, or the trademark, or all the different IPs, these all are laws, based on the law. So there are always ways on the way of your representation, right? So you need to represent in a proper way that it is non-obvious, and you can proceed, right? Invention must be something that represents an improvement over the existing product, right? It must not be obvious to a person or ordinary skill in the field, as I said. Then industrial application, mostly the industrial application will always be fulfilled for each and every product, except PMM, perpetual motion machine, and that type of machines will not be patented, right? So for all the everything, industrial application criteria will always be fulfilled. Now, again, even though they are fulfilling all these criteria, that is 3I, but there are few exemptions which cannot be patented, right? So we'll be seeing that one by one. The first is opposing the well-established natural laws. So if you are claiming that you come up with that type of machine which generates heat without any input energy, or without any external work, then free work you will be giving, free energy you will be getting, that type of machine cannot be patented, because it is against the natural law. If you are claiming that I have developed a type of refrigerator in which cooling can be done without any energy, without any scientific laws, that is against some scientific laws, right? Then that cannot be patented. The second thing is opposing to morality or injuries to public health, right? Sometimes some inventions related to atomic bomb, hydrogen bomb, right? Nuclear bomb, that type of inventions, that is something harmful, right? Even in the current situation, we can say that invention related to some viruses, invention related to some bacteria, that is harmful to human health. That cannot be patented, right? COVID is something novel. The name itself suggested novel, novel coronavirus.
So it is novel, right? And it is also non-obvious, right? But still that cannot be patented because it is injurious to public health, right? Then scientific principle or abstract or theory. It means if you are coming up with some abstract, if you are coming up with some theory, right, the theory cannot be patented. It is just a literature, right? It is your knowledge, but it cannot be patented. Then new property or use of a known substance. It means if you are coming out some discovery of some new property of the existing substance, right? If you are coming out with if you are claiming that a magnet can release radiations, so releasing the radiation is its new property. So that type of property cannot be patented, right? So property can be discovered and discovery can never be patented, right? So now, fifth point, what cannot be patented is mere admixture and processes thereof, right? Mix, adding, or just arrangement, or for the this is basically for the chemistry field or the pharmacy field, where they are adding the chemicals and coming up with the final solution, right? So just adding two solution and claiming that, for example, I can say that we are having two tablets, one is for the fever and another tablet is for cold. So that both tablet would have some content, it is prepared, right? Now you add that both the tablet together and prepare one new tablet, right? Then that new tablet will be able to solve cold as well as fever. So that is just mere admixture of the two known products, right? So that cannot be claimed as a patent. That now I have come up with a new tablet that is able to work as a medicine for fever as well as cold. No, that will not be patented because you just added, you just admixtures the process, right? Then mere arrangement or rearrangement of the known devices, each functioning independently of one another is in a known way, right? It means arrangement or rearrangement of the known devices. For example, if I say that umbrella, we all know umbrella, right? It is used for protection from the raindrops in the monsoon. And torchlight, torchlight is used to as a light during darkness, right? So if someone from you come up with a product that is having a torchlight with the umbrella, right? So you just claim that this is a new type of device that is having some light and umbrella together. So that type of invention cannot be, so basically that type of innovation cannot be patented, right? Then method of agriculture or horticulture. See here, it is mentioned that method. So method of agriculture basically means, few of you might be farmer from the farmer background, right? They will be knowing that the farmers are taking the crops alternatively. Like on the first year they grow cotton, the next year they grow the groundnut, again for the next year they grow cotton. So there is some specific pattern, 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 right? So that type of pattern or that type of technique for by which they can get more crops or more output. So by this type of process they are getting more products, right? But this type of technique cannot be patented. If some farmer come up with the new technique that once first year we need to go groundnut, in between we need to grow chili, in third year we need to grow cotton, then on the fourth year we'll be getting the maximum groundnut output crop. So that type of technique, that cannot be patented because this type of techniques need to be used by all the farmers, right? Because every farmer wants more crop output. So this type of techniques cannot be patented. But this is just the method of agriculture, not the instruments. The instruments or the devices that are used in the agriculture can always be patented, like seed drill or horticulture or tractor or anything. In that type of devices, if you make some changes, if you have some innovation, you can always patent it. So kindly note that here what it is said is just the method of agriculture. Okay, same here for horticulture. Then next is treatment of human being or animals, including the diagnostic method. The it means the process of diagnostic, or the way in which you can diagnostic any disease, or the treatment, the process of the treatment. For example, if I can say that a doctor is having one operation of kidney stone, he is making one cut on the nearby kidney and taking out that kidney stone from our kidney, and it is again sealed back, right? Threaded back. So if the doctor comes up with the technique that if the blade is made at an angle of 73 degree, then and then only the less bleeding will occur, and you will be able to have the operation within very less blood spillage, right? So that type of technique, if any doctors found out, then that technique cannot be patented, because that type of technique need to be used by all other doctors. And even sometimes the doctors are, if they are doing operation, and if they come with some 52 degree, and it happens that it is some patent from by someone else, then what they can do at that time, that they need to do patent operation, or they need to ask for the inventor that please give me permission to operate it at this angle or xyz, right? So that cannot be patented. So that is the method of treatment, right? Then plants and animals involved, or any part of it. But now plants can be patented under Plant Variety Act. So now it happens only to the animals, that if you are coming with a new breed of any animal, or if you are coming up with new creature or new insect, then that type of insect cannot be patented, right? Because it is a discovery. Then essential biological processes, then mathematical or business methods, right? uh, the techniques, business techniques, or the computer program, right? These all things cannot be patented. But in foreign countries, business methods are patented, computer programs are patented. But for India, whatever we are seeing here is limited to India. So in India, you cannot patent the computer program. You can copyright the computer program, but patent is not granted on it. Business methods, I can say example that Uber. You will know that Uber is having some mathematical techniques, that whenever you book a cab, the nearby best rated driver will get notification for the ride, and if he accepts, we get the ride, right? So that is one method, or that is some business technique, that how to get the efficiently the nearby cab to the customer. So that type of technique is already registered in USA. So no one else can use the same technique in USA. But when they came to India, in India Uber, it is available, but in India there is no any uh, patent for this type of technique. So Ola also came up with the same technique, Rapido also came up with the same technique. So everyone else can also use the same technique, because there is no any patent on it. But the first mover will get the advantage, right? So that is another form of business, right? Then literacy, dramatic, musical or artistic work, these all things also cannot be patented. These all things comes under copyright, correct? So these things comes under copyright. Then method of playing games, right? Someone of you will be playing chess, and if you are come up with some unique technique, that like 4 step or any 7 step technique. So for that, if you are getting that technique, and that is unique, but the technique cannot be patented, because others are also going to play the same technique. Like Dhoni's shot, we all know that helicopter shot, right? So it is not patented by him. Anyone can play like him at the same shot, right? But so that is methods of playing games. Then presentation of information, presentation also cannot be patented, it can be copyrighted, right? So presentations comes under copyright. So these are the exceptions which cannot be patented, even though it fulfills all the eligibility criteria, right? So now we'll be seeing one by one. For example, 3A, that is frivolous invention, right? That is invention contrary to well-established law, or machine that gives 100 more than 100% output, right? Machine that gives output without input, right? This type of inventions cannot be patented. Example, here we can see that if you are coming with a butter stick, like we saw that fevistick is there and you will be easily able to apply it on some surface. So you come up with the butter stick. So that butter stick cannot be patented, right? Because it is just frivolous. That is just application from one form to another. The second example, here you can see that in recess times you are feeling that I was not having any spoon, and every day I am forgetting the spoon. So someone come up with that type of pen that cap of that pen is saying fork or the spoon or the, then that type of spoon cannot be means that type of product cannot be patented, right? This is just a frivolous invention, right? Then section 3b, it means uh, the invention that are contrary to public order or morality. It means if you are coming up with gambling machine, or a machine that can be used for committing theft, right? Or a machine gun, or anything that is harmful to public life, that cannot be patented, right? A machine that can be printing the currency notes, right? Or if you are coming up with a technique that it is having the, it can produce the same currency note as for RBI, then the type of machine cannot be patented, right? So this is the exceptions. Then section 3C, it means discovery or formulation of an abstract, or discovery of any living things, right? Or discovery of any non-living substance occurring in nature, right? If you are coming up with some material or new metal, or something new existing gas, right? Then that cannot be patented, because it is a discovery. It was already present, you just uh, found it out, right? Then Newton's law. It was already always there, Newton's law. But Newton just came up with the theoretical proof that how it works, right? Then discovery of any microorganism, right? No, if you are coming up with some new microorganism, that type of microorganism cannot be patented. New gas, everything cannot be patented. Then mere arrangement or rearrangement, as I said, the bucket fitted with torch. Here you can see that umbrella fitted with torch. This type of invention cannot be patented. Yes, but I would like to give one example that it solely depends on the representation, how you represent your innovation, right? I will give you two examples. One is, we all have seen the pencil, right? We all are using the pencil, and the another product is a LED bulb, the 2 rupees LED lamp that we are using. So one person came up with the invention that he fitted that LED bulb with the pencil in between, right? So he came up with that type of pencil that can be glowing, or that can have a light. So now he applied for the patent, right? So do you think that pencil will get the grant of that patent? Here he have used the two known products. One is pencil, another is LED, right? And he just combined it and he applied for the patent. So will he get the patent? Yes or no? You can write it in the chat box. Yes or no, right? So the answer is yes. He got the patent on that pencil with the LED light. Why? Because he represented that he had came up with that type of invention. He came up that type of novel pencil that would be able to write during the dark, in the dark room or in the dark place, right? So previously known pencil was not able to write in the dark room, but now with this new pencil, or with this pencil with LED light, anyone would be able to write it in the dark room. So that is something new, that is something novel, that is something inventive, right? So that person got the patent. Another example, we all are using the luggage bags, right? Or we all are using the briefcase or the thela, right? Before 10-15 years, there was one coolie. He used to carry these old luggages on his head and everywhere, right? And he was so tired. He was feeling that what to do. So he just saw that on the trolley, they all were moving the luggage bags with the trolley. So he just came up with the idea that why not to give this trolley wheel to the luggage bag. So he put the wheel to the at the bottom of the luggage or the briefcase, right? And he came up with the new product, that is a trolley or the luggage with the wheel, and he patented it, and he got the grant of that patent because it is something new. It is something economical. It reduces the burden on human life, right? So from that, he now in current days he has just given that patent license to all the luggage manufacturing companies, and he is just earning the royalty, right? Just see, there is no any requirement of any research, or there is no any requirement of any in-depth R&D. You just see the problem, and if you are having some good solution, that can be patented, and you just need to represent it very well, right? So basically represent matters for filing of patent, right? Yes, patent can be filed by you own, or you can also go with some patent attorneys or the patent agents. They can be filing on your behalf, right? So here is the example that under section F, you cannot get the patent for arrangement or rearrangement of the known substances, but how you represent it matters. And if that is something new or novel, you can get the patent on it. Then mathematical method or computer program or combination of hardware and software, this type of things you cannot get patent. But currently, if there is a combination of hardware and software, you can go for the patent and it can be granted. Also, government has come up with the new policy for the computer program also. So in the near future, you will be able to get the patent on computer programs or the applications or the algorithms that you have prepared for the application, right? But currently it is not eligible. Currently, computer programs are not eligible, but combination of hardware and software it is eligible. You can go for the patent filing for integration of hardware and software. Presentation of information like spoken words or displays, symbols, diagrams, right? These all things cannot be patented, right? Traditional knowledge or the aggregation of the duplication of the known properties, right? Traditional knowledge means those uh, knowledge that is known to our ancestors, that is known to our fathers and grandfathers from the since long ages, and there is no any documented proof of it. For example, we all know that haldi is used to paste on the burn, or it is used to apply on any tear on our skin, right? આપણને ક્યાંક લાગી જાય અથવા તો ચેકો પડીએ તો આપણે ત્યાં હળદરનું પેસ્ટ લગાડીએ અથવા તો હળદર દાબી દઈએ, એનાથી આપણું લોહી વહેતું બંધ થઈ જાય, right? So that is our traditional knowledge. It is not mentioned anywhere that whenever you are getting some burn or cuts on your skin, you need to apply haldi or turmeric, right? So it is our age old knowledge. There are many different herbs. There are many different plants that are used. For cough we are using ardusi, tulsi, ajwain, right? Or many different herbs that we are also not known, we are not knowing, but it is our traditional knowledge, right? So this type of techniques or this type of inventions, if you are claiming, you would be knowing one of the case uh, that America tried to file the patent for turmeric, right? It was the same that they were claiming that turmeric can be used for healing. It is having the healing property, but it is already known to us, and as it doesn't fulfill the novelty criteria, right? Because it is already known in Indian society that uh, turmeric can be used for the healing, so they will not granted the patent on turmeric. After that, again a case for the neem leaves also came up, right? So these all are the different cases regarding IP, and based on that, our government made one portal, that is TKDL, traditional knowledge in digital library, right? Because all these things are written somewhere in our Ayurvedas or some other books that is not available in the digital form. And whenever anyone is searching for the novelty, they will be searching in the internet, so they will not be able to get that this type of knowledge is always already there in Indian public. So our government, with the support of CSIR, prepared the website TKDL, and in that they have kept all the traditional knowledge, the traditional uses, right? So in that website you can go and search for any herb and how you can use it and what are their benefits, and that all things you can uh, get from there. And this website is also used by the foreign countries. Whenever any patent related to some herb or patent related to some utility of this herbs are coming, they first see that this is not already known in India, na? Otherwise they will not grant the patent, right? So, but any value addition in the traditional knowledge leading to a new process or a product which is novel and inventive can be cannot be patented, right? For example, Vico turmeric, right? They are using the turmeric powder only, and they have added some chemicals in it, and they are claiming that by this paste your skin will glow. But we already know that by the use of turmeric, our skin will glow. So that type of product cannot be patented, right? Then invention falling under section 20 of atomic energy. As I said, that inventions related to any of the uranium, thorium, or radioactive materials cannot be patented. So now I am giving you time to read this problem. So this is how the patent works, right? So this is the problem faced by one person. Just read it, and what you understand, just memorize in your mind, and I will be going further. So here we can see that the problem that is identified is, it is difficult for conventional toothbrush. It means the whatsoever the toothbrush that is available during this time is unable to clean every nook and corner in the mouth, right? So the inventor found out that he is not able to clean each and every nook and corner of the mouth with the traditional or the conventional toothbrush he is having. So he come up with the new toothbrush, and this is the solution. So he came up with the toothbrush having a block head. It means the head of the toothbrush, a handle, and a neck portion connecting the block with the handle, right? The head is having the tops, the brush portion are made up of the filaments with a polygonal cross section, and the rest of the tops are made up of the sheath core structure filaments whose material is covered with the sheath material, so that the cross section of this becomes the concentric circles. So this is the solution he came up with the existing problem. So he came up with the new brush or new type of brush which is able to clean the every nook and corner of the mouth. So did you get it? What type of brush he is claiming? What is the new brush? So here we will be seeing that the above person. This is the old or the conventional brush for which we are not able to clean the every nook and corner of the mouth. So the person came up with this type of new brush which would be able to clean each and every nook and corner of the mouth, and he is claiming on it. So based on it, he filed the patent and he got it. So even a simple change, a simple modification which gives better output is eligible for patentability, right? So also images, by images you will be able to understand easily rather than the this type of lengthy uh, wordings, paragraphs, right? So images are also very important while filing the patent, and you need to provide this type of specific images related to your product. So is it patentable? Yes, it addresses the problem of improper cleaning of the tooth and gum. So what is the invention? So he gave the answer that it is invention related to this. What does the invention do? It provides the better cleaning between teeth and the teeth surface, right? So yes, it is patentable. So this is just for your information that there were 8,102 patents related to brush in India on 31st December 2018, right? So just think that in market we are having how many different types of brush. We would be having 5 to 7 different companies like Patanjali, Colgate, Pepsodent, Oral-B, right? And each of these brands will be having 8 to 10 different models, right? Pepsodent model 1, 2, 3, XYZ with zigzag pattern and another different type of pattern, flat pattern, right? So uh, on and all, we'll be having some nearly 100 to 150 various types of brush available with us in the market, right? But you just see there are how many patents are there? 8,000 patents. So it shows that each and every patent are not commercial, right? It is not necessary that every patent that is filed is the type of product is also available in market, right? It can be or it cannot be, right? Because some companies are filing the patent, nearby patents are also filed by them so that no one else can modify just a little and can go for the patent, right? So uh, I can say that as per the survey, only 3% of the patent is commercial or that is commercially available in the market. The product related to that patent is available in the market, right? So now we will be seeing the patented documents. These are the few patent. As I said, that each and every product around you was once patented. Someone has invented it. Someone would have innovated it, and they got the patent. So here you can see that this is the patent of pencil. It was granted in 1864. Then stapler, revolver, skateboard. So these all are the few patent documents. So now you are having any innovative idea? Do you have any patentable invention? Then you should first file it. Then and then only you need to go for publishing or giving it in a newspaper or uploading on YouTube or anywhere else in the social media, right? Because once you keep it in the market, once you upload it or once you give it in the newspaper, then it will become the public knowledge and it will not fulfill the novelty criteria because everyone will be knowing about that product, and so you will lose the novelty criteria, and after that you would not be able to get the patent on it. So first thing is, whenever you are having that type of idea, you need to first file the patent, then and then only go with the different publications, right? So what are the requirements for filing the patent? You need to have title of invention, description, detailed description, claims. Claims may or may not be, right? It means there are two types of patent application. Initially you can either file provisional application. It means you have just started your research and you would be knowing that I will be coming up with that type of product that produces some uh, for example, I am preparing that type of ink that will become invisible after 5 years. So that is my point of invention, right? I am having some, I would be having some ink, but in that probably I would be using xyz chemicals, right? I will be using sodium nitrate, silicone, xyz. So these all things I can mention, but actually how much proportion I would be using, or sometimes I would be neglecting some chemicals. So these all things I don't know initially, right? So just I can file for the provisional patent, that I will be having one invisible ink that would be probably using these 8 9 materials. So that is your provisional, so that you will be saving your priority date. So your patent 20 years starts from that date. So, and you can file complete specifications within 12 months. So after that you can get 12 months, and within that 12 months you can file for the complete specifications, right? Then abstract, whenever you are filing for the provisional, abstract is not required. For complete, extract is required. Then figures, that means sketches or the diagrams, line diagrams, name of the inventors and name of applicants, and right of proof of assignment. It means uh, if you are going with some patent attorney or agent, you need to provide a proof of assignment. One more thing you need to focus here is name of inventor and name of applicant. The name of inventor is the person who has invented that innovation or the invention, while name of applicant is the person who has applied for the patent. So the patent will be granted on whose name? Any guess? The patent will be granted to the applicant, even though person X is the inventor and person Y is the applicant. Person Y will get the all the rights of that patent. So you need to be very careful while filing the patent. So the name of the applicant in that space there should be your name, right? The name of the uh, those who want to get the ownership of that patent, right? Why this is different? Because for the different companies, the inventor can be the person who are working in their company, right, in the R&D department, but they are filing the patent on the name of the company. For example, Bajaj. So Bajaj is filing the patent on the name of Bajaj. The inventor can be the person as a who is doing R&D, and D, and he is not the owner of that patent, right? He is working, he is paid for the work, and so the company will file for the patent and company will own that patent. Company will get all the rights of that patent, right? So here this is the difference. IPC classification, it means the patent offices have classified these different patents in different class, so that it would be easy to search for the different patents while searching for novelty. Here are the 8 different classes, and based on which you can search for your patent, right? So even sometimes a single patent can be lying in the two different class also. For example, mechanical engineering as well as performing operations. So I can give you one example: that grinding wheel. Grinding is a mechanical tool, right? Machine. In that same machine, grinding wheel is also used by doctor, dentist. They are grinding the teeth, so that can be under operations section also, right? Performing operations as well as in the mechanical. So the patent related to some grinding wheel or patent related to some machine of grinding, it would be in both the classes. So you can find it from both the classes. Now patent search, basically now we need to know why, what is patent search and why it is required. So search means finding out, right? Basically finding out the information, that is called search. And patent search means that is prior art or prior patent inventions that are examined and that are similar to our invention. So whenever we are filing for the patent, we need to know that our invention is new or not. We need to find out that our invention fulfills the novelty criteria or not. So to search for that novelty, we need to look after all the prior patents, right? That the same type of invention is already patented by someone else or not. If someone else has already patented, you will not be able to get the patent on the same thing, right? So you need to modify your invention, and then only you can go for the patent filing, right? So patent search, so we need to do the patent search
in different uh, databases, right? So it can be previous patents, even in the trade journals, publications, public discussions, trade shows, brochures, products already, products in the market, research papers. Everywhere you need to find out that the similar product as of your invention is not available, na? Or else you will be losing the patent application, right? Because if the same thing is available in the market, then you will not be getting the grant for the patent. So you need to find out from all these different databases, and you need to differentiate your patent, your application from the existing knowledge or the existing patent or the existing publication, anything, right? So you need to justify your invention or your innovation, that is something new from this all existing product or some from these all existing techniques, right? So you need to go for the prior art search. So that would be where you can search on all these free databases, patent databases, from where you can go for the patent search. USPTO, from where you can get the patents of US. eSpaceNet from the Europe patent. WIPO is having world patent of more than 146 countries. Indian patent, IP India from Google also, right? So these all are the different free patent databases from where you can get the patent details of the various countries. The paid databases, some of the companies come up with the type of database in which uh, all the patents are in the one place, right? So from the paid databases also you can go for the patent search. First of all, did you understood that why this patent data search is required? The patent search is required so that you can differentiate your invention or your innovation from the existing knowledge, from the existing patent, or from the existing product in the market, right? So you need to differentiate, or you need to prove your invention to be a novel. You need to prove your invention to be non-obvious, right? Then and then only you can get the grant. So first of all, you need to find the inventions related nearby to you, similar to you, and from that you need to differentiate it out. That my invention is different from this, different from this, different from this. Ultimately, conclusion that my invention is different from all the previously known patents, right? So that type of application you need to go for it. Now fees. So for patent application fees for a natural person, these are the different forms you need to fill up while filing the patent application. So form one, that is the name of the inventors and residential proofs and that all. The fee is 1600 rupees for natural person. Small entity means a small firm that is saying less than 20 number of employees, and other than small entities, it means multinational companies or the big companies. For them, if they are filing on their name, they need to pay the fee of 8,000 rupees. Means if Bajaj is filing any patent, they need to pay the fee of 8,000 rupees if they are filing in the name of Bajaj. For you, if you are filing in your name or a group of persons, right? It means if you are a four-person group, then the name of all the four persons can be included in this form one. So you need to pay 1600 rupees only total, right? Then form 2 is the related to a detailed description. In this only form, you need to describe all your invention and all your innovate ideas. Everything you need to disclose in this form 2. Form 3 is for uh, declaration. Sorry. Form 3 is for foreign filing intimation. Whenever you are filing in the foreign countries, then you need to intimate our Indian patent office also that I would be filing in foreign nations also. So that is for form 3. So it is not mandatory, but all are filing form 3 also, because sometimes if you feel that after 5 months you want to file this patent in South Africa also, then you can directly file there. Then form 5. That is the declaration of inventorship. Form 9, it is also not mandatory, it is for early publication. If you want to publish your patent early in the patent journal, so patent journal is getting published each and every Friday. Every Friday there is one patent journal available on IP India office website, and in that only the title and abstract of the completely filed application will be shown. So if you want to publish it early after filing the complete specification within 3 4 weeks, you need to go for form 9 and you need to pay 2500 rupees, or else it will be getting published within 18 months. આપણે જ્યારથી ફાઇલ કરીએ એનાથી 18 મહિનાની અંદર ગમે ત્યારે એ પબ્લિશ કરી શકે. સો ટુ ગેટ અર્લી પબ્લિકેશન, fill form 9. Form 18, that is for examination. Whenever you are filing, they will keep the file with them only. After that we need to request them, request for exam, right? So we need to fill the form 18 for request for examination. And these are the different fees for different entities, and these are the online fees. If you are going with the offline mode, 10% more fees need to be paid, right? So these are the different offices, but whenever you are applying online, there is no any specific location. Your application will go to any of those offices, right? It is located at Delhi, Chennai, Mumbai and Kolkata. So if you are applying online, your application will go to any of these offices irrespective your location, right? Now how patent works. So briefly I will be going through how this patent application works. Here you will be able to see blue background and white background. So blue background is applicant's task. It means it is your task. So first thing is used to establish priority date application applying the patent. Now it can be you are applying in India, or you can be applying in PCT, any of the nation. So that will be your priority date. From that day your 20-year gets started. Then your patent, you can file patent application in India, then you can ask for early publication. That is optional, right? If you are asking yes, then it will be published. If you are no, if you are not asking, it will be published within 18 months. After that you need to go for request for examination, and within 48 months you can request for examination. Within 48 months, it means nearly 4 years, exact 4 years. So they can take as much time as they want, and they will be giving you the, so that after request for examination they will be examining the patent application. And if the patent application is order of grant, if it is yes, your patent will be granted. If it is no, they will issue you examination report, and within 6 months you need to respond to the examination report, right? And if it is grantable, it will be granted. Means after you respond to the examination, again they will examine. If the patent is in the order of grant, it will be granted. If it is no, they will issue you second examination report. Then you need to respond the second examination report, and again they will check it that it is in the order of grant. If yes, patent granted. If no, patent not granted. And after that there is no any other proceeding. You can go for the court hearing if you wish, right? If you want to fight that this patent need to be granted, then you can go for the hearing. So this is how the patent application process works in our country. This is only for our country, India, right? Use of patent information. As I said, that patent databases is available, right? So where you can use it, you can use it to discover whether your invention is original or not, right? That is the main purpose, to check our novelty. You can also use it for competitor tracking. TVS will be tracking the patents of Honda. Mahindra will be tracking the patents of Honda. They will be, Tata will be tracking the patents of Maruti, right? So they will be tracking each other, that where other companies are filing the patent, they are doing research on engine, or they are doing research on suspension, or they are doing research on electric vehicle. So they will be able to get this knowledge, and they can also compete. Then avoid patent infringement. So whenever you are coming up with some new product in the market or existing product, but you need to know that either it is already patented or not. If you are coming up with the patented product, then you will be sued, right? So you need to stop that production, otherwise you will be sued. For example, 3D printer, it was patented nearly in 2000, right? So at that time no one was able to manufacture 3D printer. But now after 20 years, now it is in local market in a very reasonable price, right? So if you are just manufacturing the new technology, you need to see that your invention does not infringe someone's patent. Learn more about your field of invention, right? You can get more and more knowledge about your field. Saves the cost of patenting process, right? If you feel that your invention is not patentable, then you can save this cost. Learning more about new field, you can also get knowledge about new field also. Market information, technology tracking, what will be the new technology coming up in the market, right? Because patent is the first thing that our companies are filing, and then only they will be coming up in the market. For example, today the mobile company owners, mobile companies, they are already filed the patents of much many advanced technologies, but they have not come up in the market. For example, Vivo, they had come up with the phone with the on screen display fingerprint unlocking, right? So that technology was already patented in 2018. In, Now they are launching this type of mobile phone. The same way, they are having all the futuristic models with them, but they are having one a process. Then in one by one only they are coming up in the market. But in patent database, you will be able to see what is the further technology coming. They will be coming up, right? So you can trace the technology and getting the general idea for your own application, how to prepare your patent, how to write your patent, how to write your claims, and these all things also you can get it. This all information also you can get from the patent database. So this is all about patent, basics of intellectual property, all the different types of IPs covered within a brief, and more about the patent. So if you have any query regarding the any of the different IPs, you can mail me at ceo underscore sric at ceo.ssip at the souni.ac.in, or else you can also drop the questions in the chat box. And now I will be joining in physical, and you can ask me the questions, right? Till now, if you have any doubt regarding any type of different IPs, you can ask me. Okay. Yes, thank you.